Welcome to Do It for the Case Law for Wednesday, July 22nd, 2026. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Today's docket features 42 federal appellate opinions across 9 circuits. Our coverage spans criminal justice matters including drug trafficking and firearms cases from the 6th Circuit, civil rights litigation involving Section 1983 claims and employment disputes, and constitutional challenges to search and seizure policies. We also examine business and labor disputes, securities regulation, immigration appeals, tax cases, and Social Security reviews. Subscribe to the show for daily updates on federal appellate law. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. We have 13 cases from today's docket. The disposition roll-up shows 10 affirmances, 2 dismissals, 1 vacatur and remand on the sentence, and 1 reversal and remand. We start in the 6th Circuit, where the court reversed and remanded Paul Spivak's conviction for securities fraud after finding the indictment insufficient to provide notice of the specific charges under the superseding second indictment. In a split outcome involving Kevin Fordham, Martin Murph, and Eddie Reed, the court affirmed all convictions but vacated Fordham's sentence and remanded for resentencing due to errors in the sentencing calculation. Moving to the 11th Circuit, Gray Edward Rivera was affirmed on his child exploitation convictions after the court found no abuse of discretion regarding a mistrial motion following improper testimony. Adrian Lacey's wire fraud and identity theft conviction was also affirmed where text messages from a prison cell were deemed authentic under plain error review. Alvis Alexander Braceno Yadjuras received an affirmation of his 105-month sentence for illegal alien firearm possession, with the court upholding enhancements for moving a victim to a different location and carjacking. In the 5th Circuit, the appeal by Angel Renee Sanchez was dismissed after the court found no non-frivolous issues in the Anders brief. Finally, in the 8th Circuit, Kamel El-Burki's appeal was dismissed because his valid appeal waiver barred challenges to his sentence and plea voluntariness. Back to you, David.
Thanks, James. Next, Aisha has the civil rights and Second Amendment coverage.
Thanks, David. 10 cases on the docket today, all affirmed or dismissed with no reversals or remands. In the 10th Circuit, Edward Hoyd's Second Amendment challenge to a news outlet was dismissed for failing to state a claim under Federal Rule of Civil Procedure 8, and Angelina Lawson's Section 1983 suit against Kansas judges was thrown out due to judicial immunity and younger abstention. Moving to the 6th Circuit, Dennis Loggins lost his Title VII retaliation case after a court found he lied about an assault and violated company policy by recording a coworker, while Brian Hucks failed to overcome qualified immunity for his Fourth Amendment seizure claim because the officer lacked reasonable suspicion given the suspect's different physical description. Over in the 7th Circuit, BBLI Edison's takings challenge to Chicago's rent ordinance was rejected as a regulatory measure rather than a physical taking under Penn Central. The 9th Circuit handled 4 civil rights dismissals. Christopher Lovelady's claims against Customs and Border Protection failed for lack of standing. Michael Floyd's false arrest and defamation suits were barred by his trespass and litigation privileges. Melvia Wilson could not prove causation in her whistleblower retaliation claim against Oregon officials, and Frank Hurdle's prison religious liberty claims were dismissed as moot or lacking merit under RLU-IPA. Finally, in the Federal Circuit, Alvern Weed's petition to enforce a Social Security Administration damages order was deemed moot after the agency fully paid the original award. Back to you, David.
Thanks, Aisha. Now Michael with constitutional law and habeas corpus.
Thanks, David. We have 2 cases today from the 4th and 9th Circuits. One was denied and one was affirmed. The 4th Circuit denied Shah Sultan Jaffer's petition for a writ of mandamus seeking to vacate district court orders, disqualify the judge, and compel healthcare services. The court held mandamus is an extraordinary remedy available only when there is a clear right to relief and no other adequate means to attain it, noting it cannot substitute for appeal. Additionally, the court stated it lacks jurisdiction to directly order state officials to provide healthcare services. Moving to the 9th Circuit, Still v. the City of Longview was affirmed regarding summary judgment on official misconduct and Monell liability claims. The court held that Washington Statute 9810 does not authorize a private right of action for the state law claim. On the constitutional claims, the court applied the limited public forum standard, finding the city's restrictions on speech were viewpoint neutral and reasonable. Back to you, David.
Thanks, Michael. Let's turn to Maria for the business and civil cases.
Thanks, David. We have 11 substantive business, labor, and civil cases today. The disposition mix includes 4 affirmances, 3 dismissals, 2 denials of petitions for review, 1 reversal and remand, and 1 split outcome where the court granted part of the petition and denied the rest. Moving to the 11th Circuit, the court dismissed an appeal by Diamond Realty against Monolito Hutchins sua sponte for lack of jurisdiction because the district court's remand order was based on a lack of subject matter jurisdiction, which is unreviewable under Section 28 U.S.C. 1447 and 1448. In the 6th Circuit, the court affirmed a dismissal with prejudice in a legal malpractice suit brought by the estate of Ruth Ann Johnson against the law offices of David A. Sims, PLLC, finding no abuse of discretion in denying an extension of time due to counsel's internal email backlog. The 6th Circuit also affirmed summary judgment for defendant Sarah Jones in a wrongful death action brought by Tiffany Barringer, ruling that the decedent's suicide was not reasonably foreseeable under Tennessee law. Over in the 8th Circuit, the court reversed and remanded, holding that the Federal Arbitration Act requires courts to proceed summarily on arbitrability issues without allowing merits discovery or dispositive motions to continue while arbitration is undecided.
Moving to the Ninth Circuit, the court affirmed summary judgment for King County in a condemnation action involving Amana Global Company, finding that issue preclusion barred due process claims after a prior state court proceeding determined the plaintiffs were unlawful occupants. The Ninth Circuit also dismissed a petition for review by Preston against the Securities and Exchange Commission as untimely, noting the filing was nearly 15 years after the SEC order. In another immigration case, the court granted part of the petition and remanded in Sanchez-Perez v. Blanche, ruling that the Board of Immigration Appeals erred by failing to consider a claims processing violation regarding a defective notice to appear while finding substantial evidence supported the hardship determination. The Ninth Circuit denied review in Vazquez-Saavedra v. Blanche, upholding the removal order where the petitioner failed to raise facts demonstrating a particularized threat of torture. Finally, in the Federal Circuit, the court dismissed an appeal between Midas Green Technologies and Green Revolution Cooling by agreement under Rule 42. The court affirmed a district court order denying injunctive relief in Shenzhen Jisoo Technology against various defendants, finding no reasonable likelihood of success on the merits of the design patent infringement claim. The Federal Circuit also dismissed a petition for review in Crelate v. DVA, holding it lacked jurisdiction to review an arbitrator's decision regarding a VA healthcare professional's removal under Section 74011. Back to you, David.
Thanks, Maria. Raj has the immigration and government cases.
Thanks, David. We have 6 substantive opinions today from 4 circuits. 2 were remanded, 2 affirmed, 1 denied, and 1 dismissed for lack of jurisdiction. Starting in the 6th Circuit, the court granted a petition for review in the case of Mahar Sabri Hanna, vacating the Board of Immigration Appeals' denial of his Convention Against Torture claim and remanding for an aggregate analysis of torture risk rather than evaluating factors in isolation. Over in the 9th Circuit, the court also remanded Perez-Ramos v. Blanche, finding that substantial evidence did not support the agency's adverse credibility determination regarding inconsistencies about a burn injury location and assault threats. The same panel denied Torres Cases v. Blanche, ruling that an applicant for cancellation of removal must be assessed on a continuing basis, meaning a child turning 21 during the appeal ceases to be a qualifying relative. Moving to the 4th Circuit, the court affirmed Leslie Siebert Turner versus the Commissioner of Internal Revenue, holding that the tax court lacked jurisdiction because no statutory notice of deficiency was ever issued to the petitioner. Finally, in the Federal Circuit, the court affirmed the dismissal of Reeves versus the United States, concluding that the plaintiff failed to state a cognizable takings claim under the Tucker Act without conceding the validity of the government's seizure of funds. Back to you, David.
That wraps up our broadcast for Wednesday, July 22nd, 2026. Thank you to James Taylor, Aisha Johnson, Michael Reeves, Maria Santos, and Raj Patel for your reporting today. We saw a total of 58 cases across the circuits. 26 appeals were affirmed, while 8 decisions were reversed, vacated, or remanded, marking significant shifts in those rulings. Several appeals were dismissed on procedural grounds. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction. Please subscribe and follow us for daily updates.